You know, it's kind of wild how a simple request to pour a little extra concrete can spiral into a legal battle that lasts for years. Well, today we're doing a deep dive into the official court documents of a real-life neighborhood dispute that did exactly that. It's a story about one family, their neighbors, and a homeowners association.
So here's the plan. We're going to crack open the case file and walk through the whole story. We'll start with the driveway conflict itself, then get into the 4 specific legal claims, listen in on the courtroom testimony, see the judge's final ruling, and stick around for a really unusual epilogue that happened years later. And we'll wrap it all up with what any homeowner can learn from this.
All right, Part 1, the driveway dispute. So picture this, it's 2015, in the West Ranch community in Surprise, Arizona. A homeowner wants to extend their driveway, a pretty standard home improvement project. But for their next-door neighbors, Michael and Nancy Berent, this was the beginning of a long and pretty costly fight.
And look, this wasn't just a simple grumble over the fence. By 2018, after years of this going back and forth, the Berents decided to get formal. They filed an official petition against their HOA with the Arizona Department of Real Estate. And doing that came with this $2,000 filing fee. So yeah, they were serious.
So how did it even get to this point? Well, let's look at the timeline. The neighbor's driveway gets the green light from the HOA in July 2015. The very next month, the Berents start complaining to the board. Then things get interesting. A year later, the city of Surprise actually issues a violation notice. But then nothing happens. This whole thing just simmers for a while, until it finally boils over into that formal petition nearly 3 years after the concrete was first poured. Okay, Section 2, the 4 allegations. Let's dig into how they built their case, because the Berents didn't just file a general complaint saying, "We don't like the driveway." No, they built a legal argument based on 4 very specific claims that the HOA had dropped the ball and broken its own rules. Their whole case really rested on these 4 pillars. First, they argued the driveway should be considered a structure, which would put it under a whole different set of rules. Second, they claimed it was blocking a public utility easement for a fire hydrant. Third, that the HOA just plain failed to do its job and enforce the community's rules. And fourth, they alleged that the very committee that approved the driveway wasn't even legitimate.
And this right here, this is a perfect example of what this whole dispute was about. The Berents point to the HOA meeting minutes, right? They see only one name listed under the Architectural Committee report. So they say, aha, that's proof. The rules say there have to be 3 members. But the HOA fires back saying, whoa, not so fast. The minutes only list the person who was presenting the report that day, not the whole committee. It's a classic case of evidence versus explanation.
All right, Section 3, inside the courtroom. Let's step into the hearing itself. For 2 days in August of 2018, both sides got their chance to argue their case in front of an administrative law judge.
Now, this is a super important point. The legal standard they had to meet wasn't beyond a reasonable doubt like you see in a criminal trial. It's what's called preponderance of the evidence. All that really means is that the Berents had to convince the judge that their side of the story was more likely true than not. It's a lower bar for sure, but as we're about to see, it's still a tough one to clear.
So during the hearing, you have Ms. Berent testifying for her side, arguing that the HOA should have known the driveway broke city code and that it was obviously blocking access to a fire hydrant. But then, for the HOA, Regis Salazar from the management company gets up and says, look, the committee always had 3 members, and our approval notice clearly states that it's the homeowner's job, not ours, to make sure they're following all the city codes.
Okay, Section 4, the judge's final ruling. The testimony is done, the evidence is in, and now it's all in the hands of Administrative Law Judge Tammy Eigenhier. She has to go through each of those 4 allegations one by one and make a call. One of the very first, most basic questions the judge had to tackle was this: is a driveway even a structure? See, the HOA rules had all these specific regulations for structures, but weirdly enough, the documents never actually define the word. So the judge had to go to a standard legal dictionary to find a definition.
And what's so fascinating here is what the judge decided on that point. She basically concluded that the Berents just hadn't proven their case. They failed to show that, legally speaking, a simple driveway qualified as a structure under the HOA's rules. And that one single finding, man, it just knocked the legs out from under their whole first argument. And that pretty much set the tone for everything else. It was like a set of dominoes. As you can see here, the judge ruled against them on all 4 claims. They couldn't prove the fire hydrant area was a formal easement. They couldn't show the HOA was required to act
because the law says the board may impose penalties, not that it must. And finally, they just didn't have hard proof the committee was short-staffed. The judge bought the HOA's explanation about the meeting minutes. In the end, the petition was dismissed. Entirely.
So, we're on to Section 5, years after the verdict. The judge's final order came down on September 11, 2018. So, in the eyes of the law, the case was done. Over. Fino. But the story doesn't quite end there.
For years, and I mean years, after this final decision, the Office of Administrative Hearings, the very court that handled the case, just kept receiving documents from the petitioners, the Berents. This went on for so long that in March of 2022, that's almost 4 years after the case was dismissed, the same judge had to issue this incredibly rare minute entry. In it, she basically says, "We have no idea why we're still getting documents from you, we don't have any power in this matter anymore, and we're not going to do anything." It was a final, formal attempt to close a chapter that one side just refused to let go of.
And that brings us to our final section, lessons from an HOA case. So after all of that, what's the big takeaway? Why does a fight over a little bit of concrete matter? Well, because this case is just a masterclass in how these kinds of legal fights really work, and it's got some powerful lessons for any homeowner out there.
First, the burden of proof is always on the person making the complaint. The Berents lost because, at the end of the day, they couldn't back up their claims with enough hard evidence. Second, the little words matter. I mean, they really matter. This entire case pivoted on the definitions of words like structure and may. Third, may is not the same as must. Just because an HOA can do something doesn't mean it's legally required to. And finally, a judge's final order is supposed to be just that, final.
And that leaves us with one last, kind of big question that goes way beyond legal documents and HOA rules. In any kind of conflict, knowing the rules of the fight is obviously important, but maybe what's just as important and a whole lot harder is knowing when the fight is actually over.